Hi, everyone. Welcome to our Facebook live broadcast. I'm Steve Altishan, Director of Client Partnerships here at Pacific Cascade Family Law. And today I'm here with attorney Caryn Jones to talk about mediation in family law cases and how to prepare for them. So how you doing, Caryn?
I'm doing great, Steve. Good morning.
Good morning. So before we just jump into this, you want to tell us a little bit about yourself? I know you have a history with mediation.
Sure. So my name is Caryn, as you said, and I am an attorney. I've been an attorney in Oregon since 2009, and I additionally have gone through, probably 60 hours of basic mediation and advanced mediation training in family law. And so I've done the Woody Mostyn mediation training. If you don't know him, Woody is an amazing mediator who does a really great training. So everything I know I learned from Woody. And previous to coming to Pacific Cascade, I worked as a mediator and did family law mediations, primarily with pro se parties or unrepresented parties.
Well, then that's perfect. This is going to be great. So Caryn, let's just start with a basic question. What is mediation?
That's a very good question. So mediation is a process by which the parties come in and meet with a neutral third party whose job is to assist them in coming up with a mutually acceptable resolution. So the mediator is neutral, which means they're not giving either party legal advice. So that's a big difference from if each party is working with a lawyer, or if one party is working with a lawyer and having things drafted and sent to the other party. In mediation, the mediator is neutral as to the result, and like I said, not giving advice to either party. So they can give information. So for example, when I'm a mediator, I can let the parties know what the court is looking at, just in general when they're looking at custody and parenting time cases, or I can give them information about how child support is calculated, or spousal support factors, but I'm not advising either party. So that's the biggest difference.
So do mediations always end up in a settlement? Are they forced to settle?
No one's forced to settle, and mediation, the entire mediation process is voluntary, with a little asterisk, because the court is going to require everyone to at least attempt some form of alternative dispute resolution like mediation. So, but beyond just showing up and checking that box and letting the court know, hey, we've appeared for mediation and given it a try, everything else is voluntary. So if one party says, I no longer want to participate, mediation is done. And it's coming to a conclusion is also voluntary. So if one party ends the mediation, or you're not able to resolve everything, then you would proceed with your case through either court or through your attorneys continuing the negotiations.
Got it. So let's say we do come to an agreement. We sat there, we were in your office, we came to an agreement. Is that legally binding? Do I have to stick with it?
Well, excuse me. Probably. If you come to a mediated agreement and your mediator drafts it up and both of you sign it, then that would be an enforceable settlement that if one of you decided to go back on, the other party could then take that signed mediated agreement into court and have it enforced by the court. It's not a judgment, so it's not immediately enforceable by contempt of court or anything like that, but it is an enforceable settlement agreement. The other thing to note is that, every other part of mediation is confidential. And so when you come into mediation with your soon-to-be ex-spouse, you should feel free to, raise the issues that are concerning to you, or, provide information that you may not want brought up later in court, because it's all confidential. And the purpose of that is the court wants to encourage parties to settle. And so We want it to be confidential so people feel comfortable making concessions or making offers that are less than what they may offer if they ended up in court, knowing that that's not going to be brought up and used against them later in a trial. You can't come into trial and say, well, hey, they offered this in mediation and I want that, because all of that's going to be confidential.
Well, that also makes sense. So I know a lot of people ask this question.
I kind of went off on a tangent of confidentiality.
No, that's wonderful. I mean, because it's sort of in line with a lot of the legal rules about negotiation. I mean, people aren't going to negotiate if they're going to come back, later and have someone say, well, he said this and that, that totally works.
It's similar to making us a confidential settlement proposal, but the entire mediation process is protected.
So can anyone look in it? I mean, is it a public record then or not?
No, it would not be a public record. And, even if you subpoenaed the mediator to trial, the only thing they can really say is, whether or not you reached an agreement and what the final agreement was. So, when I mediate with people, I let them know, everything we say here, any agreements that we are considering, it's all going to be confidential. The only thing that you can ever bring into court later is going to be that final mediated agreement if both of you sign it.
Got it. So how expensive is mediation?
I would say it varies widely, like any divorce case. And so some people will spend hours in mediation before they're able to come up with a result. Some people are able to, they come into mediation having a basic framework of what they think might be fair. And so they're able to come up with the final result more quickly. Most mediators bill hourly like attorneys, but the parties are sharing the cost. So you're paying your mediator likely about $300 to $350 an hour. Each person's going to pay their half, or sometimes people choose to just take that out of the property division. So it's jointly paid from, funds from the property that you're going to be dividing up in your divorce. Overall, mediation is generally a much less expensive way to resolve your divorce than litigation. Obviously, we all know trials can get very expensive. And even if you each have an attorney during mediation or on the side and you're coming into mediation without your attorneys, it's still overall the total cost is going to be a lot less than if you were to just go into court and have a judge resolve everything for you. I would say most people in a mediated divorce are going to spend probably $3,000 to $5,000 on average, and then that would be split between the two parties. So
and that could be over more than one day, it sounds like. It sounds like the meetings aren't necessarily just, okay, you come in, you're here for X hours, we either get it done or you're gone.
Well, yes. So I think there's a wide range of time commitment as well. So I'll just dive into the different options for mediation. Stop me if you want me to answer something different. So some people mediate with a mediator and don't have attorneys. And so that generally was what I did when I was mediating. So I was the mediator. Each party would just come into my office. We usually do about a 2 to 3 hour session at a time. If we need more time, the parties would come back, a week or two later, do another session until we get to the end. So some people need 1 to 2 sessions. Some people would need, 4 to 5 sessions. And so it really just depends on the parties and how quickly they're able to come to a resolution. The other option is usually the mediator will do it with represented parties. So each party has an attorney who's advising them and advocating for them, and they all come to mediation. And usually what that looks like is you've hired the mediator for the day. You're all going to be there for probably 8 to 10 hours. It's a very expensive day because each person's paying their own attorney as well as half of the mediator's cost. But again, the cost of that very expensive day is a lot less than a day in trial. So still, you're probably coming out ahead if you're able to come up with a mediated agreement, even if you have your attorneys there. So that's kind of the two most common options.
That makes total sense. So is mediation the answer for everybody? I mean, how do I know if mediation's, right in my case?
Well, I think, again, the court is going to require pretty much everyone to mediate. The exception would be if there's a restraining order. Some mediators are comfortable mediating, even if there is a restraining order. We would just have to make accommodations so that the parties aren't violating that restraining order. If there's domestic violence in your relationship, or any kind of power dynamics that are concerning, that can affect each party's ability to negotiate. So if that's the case, if you want to mediate and you have concerns about domestic violence, it generally makes more sense to do the kind of mediation where you have an attorney, so that you have someone there to advocate for you and to kind of have that barrier if there's been domestic violence in the relationship. So that would be one consideration. I don't think it means you can't mediate. It just means you need to take additional steps to make sure that each party is safe and able to negotiate appropriately. Other than that, I think everyone should at least give it a try. It's a great way to resolve things, especially if there's children involved. A trial can damage the co-parenting relationship for years, if not forever. And so it can really help people who are going to have to deal with each other for the next, 18 years or less, so that you're able to have a functional co-parenting relationship going forward.
Yeah, good practice for trying to work things out the next 20 years.
It's true. There's going to be ongoing, things you have to resolve after that divorce if you have kids. And then when you have a parenting plan, I think that a lot of times people are a lot more likely to stick to a parenting plan and abide by the rules if they have agreed to them versus if they've been imposed on them by a judge and they're upset about the result. So that can also be a benefit to co-parents, for the rest of their co-parenting relationship.
Oh yeah. So do I have to agree on everything? Can we agree on X, Y, and Z and not on A, B, C and go from there?
Absolutely. You don't have to agree on everything. You can come into mediation and resolve your parenting plan, but say, hey, we still can't agree on custody and child support. And so we're going to need to go to court on those or continue working with our attorneys on those. What I usually tell people, either as an attorney or as a mediator, is the more that you can settle outside of court, the better. So even if we can only settle, 2 out of 10 issues, that's going to make a difference in the amount of time your attorney needs to spend on trial. And so it's always worth giving it a try and agreeing to whatever you can.
So you convinced me. I have decided to use mediation. How do I start? I mean, what do I need to even put together to get prepared for it? What do I got to go out and find?
I mean, the more information you have, the better. I think that applies in mediation or with your attorney. The more organized you can be, the more, Oregon has a lot of required discovery. So the more that you have of that, the better, because then, often we'll start with a mediation and we'll get into some financial details and the parties don't have all of the information available. And so we say, okay, this is all we can do today. Go find those answers, figure out what's in those accounts or where those things are. And then we'll come back once we have more information. So that's knowing what's in every bank account, all of those kinds of things, what people's incomes are, what your taxes are. The more information you have, the better your mediator is going to be able to help you, especially on financial issues.
And the less money you're going to spend on your mediator. If you don't, have to come back again after you've, gathered stuff.
Or your attorney. It applies for mediation or, with your attorney. Generally, when parties come into mediation with an attorney, the attorneys have kind of done all of that work that needs to be done. So they should come in a little more prepared. If people are representing themselves, they may show up to mediation not knowing what they need or not knowing all of the details of the finances. And sometimes that's something we have to work on in mediation is letting people know, hey, here's the discovery statutes, here's what you do have to provide to the other party. And so you're going to need to be able to provide that if either of you needs that information. And then they can go get that information and exchange it.
In your mediation experience, do you ever see spouses who are kind of come to you and say, look, we don't hate each other. We just need to get this divorce. And, what can we do to work together to get ready for the mediation? I mean, is that a no-no, or is that something that you would maybe encourage?
No, I think when I was doing mediation, I would definitely encourage people to come up with as much as they could together, because that saves time in mediation. So I can provide them with the discovery statute. Obviously, I can't give either of them legal advice, but I can say, hey, here's all the documents the court's going to require you to exchange. Some people don't feel like they need to exchange all of those documents in mediation, and that's okay. We just put in something in your judgment that says, hey, everyone agrees that they've had enough information to make the decisions in this divorce. But so, not everyone feels like they need 2 years worth of the other party's credit card bills. And they just want to know, hey, what's on the credit card right now? But I would provide each party with that discovery statute so they know, okay, here's all of the documents I'm going to have to provide if we're not able to settle this in mediation, and that can give them a place to start.
Are there forms that you're going to get to help with either coming up with this information or putting it into some form? I mean, do the mediators generally have forms they give out to the folks?
I think that probably varies by mediator. I think most mediators, if you're doing this with people who are representing themselves, I think most mediators are probably going to give them an intake form of some sort that says, hey, let me know all of the basic information. What do you know about your finances? What are the accounts? What's out there? What do we need to resolve? So they'll have some kind of intake form similar to what your attorney might have. And then other than that, I don't know, there may be some mediators who have more forms and some mediators who just don't use forms and take that information as they're mediating. Some of that information, like the basics that go into the vital statistics form and things like that, are going to be on an intake form because that speeds things up.
If, let's say I'm not either represented yet by an attorney or the attorney's helping me, but I'm doing the mediation, and I'm looking for a mediator, are these the kinds of questions I can ask the mediator first, kind of how they do it, what what it costs, what expectations they have of the people when they come in?
Absolutely. When I was doing mediation, I used to do a free 15-minute phone call for each party in the mediation so that they had that opportunity to ask, what I would want from them, what the process looks like. And also to get a feel for who I was as a mediator, because that's really important. Mediation, again, is voluntary. And so each person has to agree to use the same mediator. If you're doing the court-connected mediation where you go through the county for custody and parenting time issues, you don't really have much choice. You just go with the mediator that the court assigns you to. But if you're doing a private mediation, each party has to agree to use the same mediator. So it is important to connect with the mediator, get a feel for who they are, how they operate, what their procedures are, and make sure that each of you is comfortable using them before you start the mediation.
That leads to a question. So mediation then it's not just about a divorce proceeding, I take it. There are maybe, on modifications, or you just want a custody, or you were never married. Can mediation work on all of those other kinds of family law matters?
Absolutely. You can mediate really any family law matter, from a prenup to a separation agreement. If the two of you want to come up with a framework for how you're going to operate during a separation while you try to see if you do need to file for divorce or if you want to move forward, a mediator can help you sit down and come up with, a plan for where the kids are going to be while you're separating and how we're going to pay finances. And you don't even need to file the separation or the divorce. You can do sort of an extrajudicial mediation to get you through that separation period where you decide whether or not you're even going to file divorce. So I think mediation is a great tool for all of those kind of situations that might fall outside of normal litigation, as well as being used for divorces, modifications, needing to establish custody and parenting time.
Sounds like it's a pretty flexible way to try to resolve your problems. So let's say
Right.
I have a bunch of things I want to say to the mediator. Well, I've looked through my stuff. I've gotten ready for it. But it's so easy to know what you want to say and then go into a meeting like that and forget. How do I make sure, that the things I want to make sure I tell the mediator, I tell the mediator?
That's a good question, Steve. I would highly recommend, when you're calm and outside of mediation and able to organize things, making yourself a nice list of everything that you want to make sure that you cover in mediation, and then looking at that before you end any mediation session so that you can make sure that you've covered everything. I will jump ahead, I think, maybe to meeting separately with the mediator. So, if you have your list of things that you really want to make sure the mediator knows, but some of them you're not particularly interested in talking about in front of the other party, that is something you can do in mediation. Again, whether you have an attorney there or not. If I was working with two parties who were not represented by attorneys, either if a party requested it or if I felt like it would benefit the parties in a mediation, we can do what's called caucusing, which means that I would put one person in one room and one person in the other room, and I would just go back and forth between them. And sometimes that can help, if I was observing that the parties were just really stuck on an issue and I thought it might help to talk separately with each party, I might do that, or if either party requested it. And so that's something, when I was doing mediations, what I would do in the first session is sit down and talk to the parties individually, just to give them an opportunity to get, there's a lot of emotion going on in all divorces and custody cases. And so give them an opportunity to kind of get all of that off their chest, to give me some information about where each person is coming from. And then that helps me as the mediator to move them closer to the middle and to get them to a resolution, even if I'm not disclosing that to the other person. So whatever the person wants to tell me in that caucus session, I would keep confidential, unless it was something like, my favorite example to use is, oh, by the way, I'm pregnant and he doesn't know it. Well, you're going to have to tell him that. That's going to have to come out. And then we would talk about, okay, how are we going to disclose that one? So, but other than, something that would be required to be disclosed in order to continue the mediation, that would all stay confidential.
Yeah, they can't tell you they're going to, rob their business of all their money and go to Mexico.
Right. And I let
they
them
can
know
tell you, but you may have to say
too.
something.
Right.
So is this something that can also happen before the actual mediation meeting between the two of you? I mean, is there times when someone may call you up the day ahead or 2 days ahead or whatever and say, look, here are my concerns for the mediation that we're having tomorrow? Or does that all kind of occur in the mediation itself?
Sure. I would, if a party wanted to call the mediator prior to that, I think mediators may vary on how they deal with that. When I was mediating, I would, if one party wanted to have a call, I would essentially treat that as a caucus session. So no different than if we were meeting separately in a room in a mediation session, it would be the same thing. So I'd consider it part of the mediation. I would bill them for it. But
it's allowed.
Each person is allowed to talk to the mediator separately. Again, no legal advice is going to be given in those separate meetings, but you can give the mediator information that you don't necessarily want to share with the other party.
So another issue that I know kind of happens is, getting ready emotionally If I come into you and I say, I've got this mediation and I really want to win, that's all I care about is winning. How do you get them to maybe shift from that to try to mediate, to work it out?
Well, I mean, if your only goal is winning, mediation isn't going to be very productive. So I think in that case, I'd have a conversation with the person about, well, what are you going to benefit if you get everything that you want? How will that benefit you? And kind of refocusing them on what are your real goals? How do you want to see your life after this divorce is final? What is your vision for your children, and how can we get you there in a way that is collaborative and benefits everyone, so that you can get through this divorce without spending all that money and going through the emotional trauma of a trial.
What about let me be winning, but I want to convince the mediator of this. It's important the mediator understands that this is true and that is not true. That I have to convince that mediator in order for the mediation to work. Is that correct?
No, I don't think you need to convince the mediator. I think it's helpful to provide the mediator with information about why you're wanting what you're wanting. But the mediator's job is not to decide who's right and who's wrong. Their job is not to decide what the result should be. Their job is to facilitate that conversation to get the two of you to a result that you can agree with. And so it's helpful to give the mediator the information about why you're asking what you're asking, or why something is important to you. But always keep in mind that the mediator is not there to make a decision or to decide who's right.
I think that's really important for people to know. That's what mediators can do and what they can't do, kind of a thing.
Right.
So there's another thing. There's all these things that may be going on in the divorce, and they're taking you in different directions. How do I really know what I want? I mean, it's kind of a weird question, but I'm assuming the mediator's going to say, what do you want? And, I could say, I want this, that, and that, but is that it? Or, I mean, how do I know what I really want?
That's a good question, Steve. What do you want? Well, I think that if you really go into a divorce having no idea what you want, that might be a situation where you might need some legal advice. And so I would recommend that you would meet with a lawyer, because the mediator can't give you legal advice and can't tell you, what is best for you. So even if you're coming to the mediation without your attorney, and you're just, you and your spouse or soon to be ex-spouse or co-parent are coming into the mediation just by yourselves as pro se parties, you can have an attorney on the side who's advising you, whether or not the other party has an attorney. And so you can meet with your attorney before mediation and get an idea of, what is my best case scenario if I go to court? What is my worst case scenario if I go to court? What should I be asking for here? And what's reasonable? And so that's your attorney's role, is to give you that information and advise you about, what you should want, what's realistic for you. And then you can use that information to go into mediation and, know where you can concede and where you can stay firm, because okay, well, here's my worst case scenario if I go into court.
Again, that's really important to know. It's not, a mediator's not going to say, well, you do this, you're going to get killed in court, you're going to win that, you're going to do, yeah, that's not their job.
Correct.
What if I got emotional triggers? A lot of people, the other party has gotten and knows what your emotional triggers are. And what advice would you give to people to kind of prepare that their emotional triggers just may be hit?
Mm-hmm. Well, I think that emotional triggers, and especially if people have, a lot of trauma from other aspects of their life, from the marriage, from the relationship, all of that is really important to let your mediator know. So in those initial meetings where you're maybe meeting separately with the mediator, the mediator should be doing a domestic violence kind of questions to get a feel for if there is any kind of power and control issues or domestic violence issues. So in those meetings, if there are things that are really triggering for you, and not necessarily domestic violence, but just, gosh, I'm still really mad that he spent all that money on that jet ski. Those kinds of things that could be triggering to you during a mediation are good to let the mediator know. So that way the mediator knows, like, okay, this is coming up and maybe I need to give everyone a 5-minute bathroom break, or go take a walk and manage your emotions. So number one, let the mediator know of any important emotional triggers or trauma that you have in your background. And then number two, set aside some time for yourself before or after the mediation, so that you can, do some self-care, go for a walk, talk to people, and also know that either person can take a break at any point in the mediation. And so if you need 10 minutes, feel free to say, I just need to take a walk, or I need to go have a cigarette, or whatever it is that you need to do so that you can stay in control of your emotions during the mediation.
That I love that, because that seems to me that it's where mediation can go really wrong really fast. It's sort of, the best laid plans of mice and men after getting ugly. Just, you can do all your planning, do everything, and it can just unravel at the time. And just as a final, we're almost at the end. We've already hit 30 minutes. But maybe a couple of thoughts go, as we leave, about not letting your emotions get in the way, but maybe not necessarily holding them, because maybe the mediator wants to know something about them. Maybe that's important, but kind of, when you're in there, when you're in the heat of the battle at the mediation, and there's maybe no one but the two of you and the mediator, what can they have in their mind, from you that can help?
Well, I would say that, and when I was mediating, I might even jump in a mediation when things are getting heated or emotional, whether I separate the parties and have this conversation with them individually, or whether I do it together, just to stay focused on the benefits to you of resolving this through mediation. Financial benefits, emotional benefits, maybe not in the heat of the moment, but the overall, the process of mediation, even when it gets heated and emotional, is a lot easier on people than, sitting through a 5-day trial where you're going to have to say all of the things that you need to win your case that are going to damage that relationship even further. So staying focused on that. The goal is to come out of this with the best result that you can get, in a more collaborative and less expensive way than litigating it. And it's not always possible to solve everything through mediation, and that's why lawyers stay in business. If everyone was able to just get everything done collaboratively, I think we would. But the more you can resolve outside of court, the better. And I think that's, the policy of the state and the courts as well, is to encourage that, to really encourage people to settle things outside of court whenever possible. So my advice when things are getting heated is just to keep your mind focused on that end goal of coming up with a result, keeping yourself out of court. And, if you have kids, there's long lasting benefits for your kids by doing that. And even if you don't have kids, it's just your own personal benefit of taking charge of the result.
Yeah. It's a place where you don't have to burn your bridges. So don't burn your bridges.
Right.
Well, we are unfortunately done, and I really want to thank you. This was incredibly informative. How mediation works, how to prepare. Always, again, as normal, you make complex issues, complex rules, and what seems daunting challenges clearer and easier to understand. And I really thank you for that, and thank you for being here today.
No problem. Thank you, Steve. It's always a pleasure to hang out with you and chat about mediation or any other legal topic.
Well, we'll get you again. I can
All right.
guarantee. And
Have a
everyone
great-
else, I want to thank everyone else for joining us today. Anyone further questions on today's topic, post it here. We can get you connected with Caryn or another one of our attorneys. And until next time, stay safe, stay happy, and be well.